JM Properties versus Eric Benoit, Jacob Benoit, and Susan Benoit. Case number 20E010347. Welcome. Please state your names for the record.
Jason Elleman.
Thank you.
Emily Dahl.
Thank you.
Susan Benoit.
Eric Benoit.
But you are Jacob,
Yes, sir.
and you're Eric.
Yeah.
Eric, that's a great looking face now.
Thank you.
And I like the kitty cat one too.
Thank you.
Not a Red Sox fan?
Well, that's okay. I won't hold it against you.
I'm a Patriots fan.
They didn't, well, okay. We'll leave that alone. All right. Thank you. This is before the court on a 30-day no-cause notice. If I can have you all sworn in, please.
Please raise your right hand. You solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Okay. Yes, ma'am.
Can my brother-in-law sit down? He has a bad leg.
Oh, sure. Yeah. I can make one with that. You got a seat there?
You can keep it strictly though.
Yeah, I mean, I don't care if they all sit down.
I don't know that myself, so.
Okay. All right. All right, this is again, before the court on a 30-day no-cause notice. It appears that the lease expired on July 31st, 2020, is that correct?
Correct.
And the lease provides that unless there's a 30-day notice prior to that date, then it converts to a month-to-month tenancy. Is that your understanding?
Yes.
Okay. All right, and there was a 30-day no clause served on September 15th and a 5-day unlawful detainer served on October 19th. Is that right?
Yeah.
Okay. Somebody states uncovered person under the temporary halt and residential evictions in their response. I don't have it in front of me, but I'm not sure who filed.
I thought.
You filed? Okay, that was Jacob, right?
No, Eric.
I'm sorry, I'm getting you mixed up. Okay, is that the sum and substance of your defense? Anything else, sir?
No.
Nothing else? Okay. All right, are you out though?
No, sir.
No.
Were you working on getting out by chance?
We're trying, but
We're
it's
trying.
hard. We're trying to save up.
Okay, so you're kind of in the save up mode right now.
Yeah.
Not
Yes.
sometimes people come before me and it's 1 foot in, 1 foot out, and they're close to being out. Okay.
We could be out by January 3rd.
Judge, if I may, in addition to the 30-day notice, they haven't paid rent in 6 months, so I would imagine that would be saving up, but I know that the rent doesn't have anything to do with this, but I'm just saying,
That's
I
correct.
would think that would be a savings to help them move.
If there's income. Right?
Correct.
Then okay. So the lease does have a holdover section. Does say you or any occupant, invitee, or guest must not hold over beyond the date contained in your move-out notice or our notice to vacate. Do you have any argument about that and their CDC?
This has nothing to do with rent. It's, we bought the building in February, and we've been, as everyone's lease has expired, we've had everyone move out and remodel their units. We've done 21 units so far this year, and it has nothing to do with non-payment of rent. It's just the lease is over, we need to remodel the units, and then that's what we do basically. We accept, re-rent them and then sell the properties.
Yeah, I've certainly seen you do that in properties. So it's kind of a complicated issue. I have a lot of cases under advisement right now where I have no lease or the lease is unclear or does not have a bargain for condition whereby the parties agree with a termination notice that they can part ways. The CDC order states that, there's 5 things you can evict for, and the 5th exception is a violation of any other condition of the lease that is not non-payment of rent.
Right.
So where the parties have agreed that, or at least the tenant has agreed that the lease can be terminated, in other words, they can provide a notice, the court has, and it's not vacated, the court has recognized that as another lease violation. And I haven't moved forward with evictions where it's unclear. You've seen me take a bunch of them under advisement because they don't have a lease. Those are generally weak lease. And the courts had, the court's legal counsel doing some research and assistance with trying to determine the applicability of the CDC order. And this is not the most clear lease, but it does have a holdover section, and it does state that the tenant must not hold over beyond the date they give as a move-out notice or the date that the landlord gives as a move-out notice. Court understands this is not a demand of an eviction demanding payment of rent. I know for a period of time, when the governor's directive was in play, Directive 025, he did, and he was concerned that the no cause notice might be used as what he called subterfuge for an eviction for non-payment of rent. However, that directive was terminated with this Directive 031, effective as of August 1st. And that permitted then no cause evictions to move forward as of September 1st. The question again becomes kind of whether there's CDC applicability or not. The court has determined that where there is the condition regarding holdover and the tenant agreeing to or understanding, in this case, that they cannot hold over, the court has found that to be another a violation of another lease condition. Will be consistent. The prior case had the same language, in fact, the exact same lease. So I will find, because the unit hasn't been vacated, unlawful tenant and order summary eviction. Folks, an order will go out to the court, won't go out until, is there something else you want to
Yes,
provide?
we have this.
What is that?
It's not a court date for December 7th. And we have,
Well, I'll take a look.
That's for a 7:30, so it's
Okay.
separate.
Why don't you provide it to? So Mr. Elleman states that, this is an order setting a hearing and notification of mediation. So you've been served a 7-day pay or quit notice, correct?
right,
And so if you filed an affidavit and the landlord filed a complaint, just by rule, the court kicks this out, had to set it 30 days out to accommodate the mediation rules, and I presume you had elected, I don't know, either you
yeah,
elected for the mediation.
yeah.
So there is this, a lot of landlords, they don't know how I'm gonna rule on their first matter, and so this is probably just your backup plan, I presume.
Correct.
And so I'm gonna marshal this is there. So while I get that you've got a date, that would probably be vacated, depending on what transpired here.
Your Honor, can I ask you something? Can we have till the 30th of November?
Mr.
Yeah.
Elleman?
I feel that they've already had 6 months We unfortunately need to take possession of it as soon as possible. I mean, honestly, if you do the 10 days, that'll probably put them at around the 30th, I believe.
Are you objecting to 10 days? I'll give them 10 days if that's.
I would not like 10 days if we don't have to. Like I said, I believe they've already had 6 months, and that's been plenty of time, in our opinion. I understand, their hardships or whatever more time they need, but we also have hardships on our end as well in terms of lost income. So if we could get them out as soon as possible, that'd be appreciated.
Well, this is what I'm gonna do. I'll give you a little bit of time. 10 days would actually be the 22nd. I will order, so I will grant the eviction, but I will stay the eviction, which will not go out until next Wednesday, the 18th. And the constable may post it on the 19th, that's a Thursday, but would not be there until the 23rd. That will give you a full 10 days.
Okay, thank you.
So good luck to you. Sorry,
Thank you.
it's tough out there for everybody.
Yeah.
Thank you.
Thank you.
All right.
Sorry.
Um,